Mr. Gonzalez, give me your full name and date of birth, please.
Paul Benjamin Gonzalez, 7.
All right. And you're with counsel.
Good afternoon, Your Honor. Brian Russo on behalf of Mr. Gonzalez.
And we're not notified by the county. Oh, yes, we are. All right. I wasn't notified, and from the county attorney's office is
Barbara Paris-Gondola for the state, Your Honor.
all right. Mr. Gonzalez, you were arrested yesterday and charged with the following offenses. 3 counts of aggravated assault with a deadly or dangerous instrument, Class 3 felonies. 1 count of threatening or intimidating in gang fashion, a Class 3 felony. 1 count of assisting street gangs, a Class 3 felony, and 1 count of possession of a weapon by a prohibited person, a Class 4 felony. Mr. Russo is here to represent you. As your counsel has indicated, he will represent you not just for the initial appearance, but for all further court proceedings. Is that correct, Mr. Russo?
Yes, Your Honor.
All right. Does the county attorney's office have a position concerning any release conditions for Mr. Gonzalez?
Your Honor, the state's recommendation for bond is a $50,000 cash bond with conditions to not possess a firearm, not to return to the incident location, electronic monitoring, no contact with any gang members, no direct or indirect contact with the victims, house arrest and curfew, and no contact with the co-defendant. As laid out in the Form 4, this was a very intimidating, volatile, and dangerous scene carried out against these 3 victims who were just minding their own business. Moreover, he is a prohibited possessor, and numerous firearms were found under search warrant in his bedroom. Thank you, Your Honor.
All right. Mr. Russo.
Judge, I'm going to go in reverse order. First of all, he is not a prohibited possessor. In CR 2015-100703, he pled to a Class 6 open on February 25th, 2015. On February 21st, 2017, he was successfully discharged from probation, and his offense was designated a misdemeanor. Your Honor, similarly in CR, one moment, Your Honor, CR 2004-04-2958, he pled to a Class 6 undesignated offense. In April 11, 2007, he was successfully discharged from probation. That offense was designated a misdemeanor. He has no other felony convictions, and in fact has no felony convictions. Therefore, he is not a prohibited possessor, and I would respectfully move the court to find no probable cause with regard to that particular offense.
Let me check with does the county attorney want to respond to just that particular argument?
I have a legal assistant who ran a JWI and came up with the history, and she's very careful, and she has the ag assault as a felony conviction. Also, pretrial services notes that he has a felony conviction. So based on those things, I believe there's certainly enough of probable cause to find probable cause at this IA setting.
The only thing I would say,
go ahead. Well, I was going to say.
The only thing I would say, I haven't seen anything that Ms. Paris-Gondola is referencing. I take her at her word. I've known her for a very long time, and I know she's a prosecutor of integrity. I would just say I haven't seen that, but I did thorough research as well. I spoke with my client. I have the paperwork discharging him successfully and designated a misdemeanor, and the court could easily access those records more easily than I can. Either way, Judge, that really isn't the one I think that the court is going to focus on as much as the others. I only point it out because it's simply not true, and we'll take care of that downstream. But Ms. Paris-Gondola referenced it in regard to weapons in the home. This is Arizona. We have a constitution similar to the federal constitution. Guns are not illegal in Arizona. Your Honor, the prosecutor also stated that these people were minding their own business. That's simply not true. If you read the Form 4, what happened was my client's daughters left the house. They're 12 years old. They saw people breaking into a car. They went back and they informed their dad. Their dad went out and asked these people, what are you doing?
By the way, the form, I didn't see that in the Form 4.
Oh, okay. I'll point it out to you, Judge. So, Judge, on page 4 or 5 Defendant asked the victim if they were stealing the vehicle and if they lived in the area.
Well, okay, what I'm saying is, the part that they had been told by his 12-year-old daughter that there was something unusual going on somewhere and they were just investigating. That part I don't recall, but go ahead. I didn't see that.
Judge, I'm giving you context of why my client went outside, and he saw these people in the car. The victims admitted they were actually breaking it, but it turned out it was their own car, and he was asking them what they were doing. Obviously, it escalated from there, but it's not as if they were just sitting in their yard doing nothing.
They obviously had a reason to come and talk to the victims or to confront them or carry on a conversation with them. I just did not know that was what your client, and I didn't read in the Form 4 anywhere where a 12-year-old girl told him that somebody's...
I'm making a proffer to you, Judge, so you had context. That's what I'm telling you.
Okay.
This is what happened, and that'll later on be part of the discovery. But anyway, Judge, as you know, and that's another point that I was going to make, the least weighted factor is the weight of the evidence against the accused, because he enjoys the presumption of innocence. He is presumed innocent. He doesn't have the discovery, and we get to go on and do our investigation. But let me tell you a little bit about Mr. Gonzalez, Your Honor. He's lived in Arizona since he was 12 years old. He served in the United States Navy. He was honorably discharged. He has been at his employment as a project manager and serves as a project manager for Diamond Assets since 2011. He owns his own home in Mesa. His mother, his daughters, all of his kids, and his wife, with whom he's been married for 20 years, all live in Mesa, Arizona. Your Honor, he graduated high school and has some college as well. And as I said, he has no felony criminal history. I think $50,000 cash bond is not the least onerous burden, and it's certainly not necessary. He's not a flight risk. He's here. All of his family is here. He's not going to leave. He's not a danger. He will follow the admonitions of the court. In fact, there's a history. You don't have to take my word for it. There's a history of him following court orders and successfully completing probation. He will continue to do that. He's retained counsel, and he will successfully defend his case. I think if the court is inclined for any kind of bond, it should be a $10,000 secured appearance bond. The location is actually his own neighborhood, but he won't go to the location of the neighbors or the victims. And I think she said no contact with the co-defendant. We can sort that out later. Obviously, there'll be a joint defense agreement, and that's something our Constitution protects, and case law in our state protects as well. And so we'll deal with that at a different day. That's fine if the judge wants to put that. No contact with gang members. Again, that has not, I don't see that there's any basis for that. This was someone at their home asking if someone was stealing a car or not. So for all those reasons, Judge, I would respectfully request an OR release. He will appear. He's not a flight risk or a danger, and he'll follow the conditions of this court.
All right, let me just, Madam County Attorney, Deputy County Attorney, I'll ask you to respond, and if you have a response in a moment, but I will tell you that the documentation I'm provided is a document entitled Criminal History, and it has failures to appear. Then under that is felony convictions, and it says total of 2. It says that on February 18th of 2015, he was convicted of aggravated assault on a control officer, and on February 21st of 2006, he was convicted of unlawful use of a means of transportation, which this is listed under the felony conviction portion of the documentation I'm provided. Does the county attorney's office have a response to Mr. Russo's position?
Are you talking about priors or the factual scenario?
Well, any. Go ahead. I would say that the record that I received, which has always been accurate to my satisfaction. I don't know that it's ever been incorrect about one of these things about prior convictions and whether or not it's a felony or misdemeanor until this case. But is there anything you'd like to respond to anything that he mentioned in his comments so far?
Thank you, Your Honor. So I mean, it seems like you're corroborating that what you're seeing is that he's a prohibited possessor with felony, so I wouldn't argue against that. I'm glad you can say you're seeing that too. And as far as the Form 4 and what it laid out, flight risk or not, it's a risk to public safety. We can say how it started, but it goes on to a lot of detail about Hell's Angel tattoo, the things he was saying. You're about to find out who I am. So it's those things that are the basis for why the state is asking for the $50,000 cash bond. That's all I have to say.
All right, well, and based upon and again, this is merely what the prosecutor's office has put together based upon what the police department obtained from interviewing witnesses. They were consistent in the things that the Form 4 says, and Mr. Russo, I'm going to set a $25,000 secured appearance bond in this case. It's not cash only. Conditions of his release include not returning to the scene of the alleged crime. I don't know if it's in your client's neighborhood. I don't know that this didn't happen at somebody's house. I don't know anything, but except to the extent that if it is somebody's house in that neighborhood and they were visiting those people, he's not to return there or have contact with victims or witnesses, and he's not to possess weapons, which, if I understand from the information I've received, and again, I've never ever been misinformed on that particular part information I received. If he has a felony conviction and he hasn't had his rights restored, then it would be a crime. And the county attorney's office lately has been very aggressive in prosecuting those particular offenses, if you didn't know. His next court date will be July 11th at 8:30 in Superior Court in downtown Phoenix. And we'll provide you with a copy of the order. I modified it slightly from what it was. Did you get that? Okay. And we'll be able to hand you a copy. Did you get a copy already? The original? Okay.
Judge, your order is very fair. I appreciate you taking the time. I won't belabor this. I just want to let you know I'm not trying to mislead the court. I have the Maricopa County Superior Court docket and minute entries, both showing misdemeanors for those offenses. So anyway, that's an argument for a different day.
And again, you have,
I wasn't trying to mislead you.
I'm glad you brought it up, and this is the first time that it's been a problem like it has become. And if there's some way you find that the kind of information I'm being provided is not correct,
I understand.
Let me know.
I understand. Thank you, Judge.
For future cases. All right.
Thank you, sir.
All right, and the next case will be, let me see, number 12 on our docket, Anthony Quillen. Full name and date of birth, please.
Anthony Allen Quillen, 4.
Yes, Your Honor. Justin Whittington appearing on behalf of Mr. Quillen.
And the county attorney's office is represented by?
Barbara Pierce-Miller, Your Honor.
All right. Mr. Quillen, you were charged yesterday with committing the offense of disorderly conduct with a weapon, which is a Class 6 felony. You have counsel here. I didn't know that at the time. Counsel, I was not informed that you'd filed a notice of appearance. You go ahead.
I was just going to let the court know that I filed it by hand filling it out prior to the IA gave it to your staff.
Well, and what I did is I appointed the legal defender's office because I didn't know any different at the time. So that the release order will have that on there, but for the reason I just explained. Does the county attorney's office have a position concerning any release conditions for Mr. Quillen?
Yes, Your Honor, the recommendation here is for a $25,000 secured bond, not to possess a firearm, do not return to the incident location, electronic monitoring, no contact with the co-defendant, no direct or indirect contact with the victims. This is the same scenario, so the same information in the Form 4 that we were just referencing, it, of course, in the Mr. Gonzalez case, the same intimidating, volatile, and dangerous scene. Here, he is not a prohibited possessor, but nevertheless, he is an accomplice with the co-defendant, and he did brandish the firearm to participate in the intimidating scene. Thank you, Your Honor.
All right, Mr. Whittington.
Yes, Your Honor. At this time, defense would request an OR release in this case. Mr. Quillen's been an Arizona resident for 26 years, and for 17 of those years, he's resided in the city of Mesa. He's currently married with children, has joint custody with his ex-wife of their shared child. His mother and his ex-father-in-law, they also reside in Mesa. He is employed also by Diamond Assets. He's currently on medical leave. As the court saw, he is currently walking with a cane due to a motorcycle accident on April 29th and the subsequent surgery. The allegations in the Form 4 that he brandished a weapon, he has a constitutional right. He is not a prohibited possessor, as the state said, to carry a firearm. He kept it in his waistband, allegedly, at all times. This was a situation where a gentleman with a physical handicap was out on the street, and there were 3 people allegedly appearing to break into a vehicle. He's allowed to have a firearm with him for his own protection. He did not draw it. He did not point it. He did not fire it at anyone. He has graduated high school. He earned a phlebotomy degree in higher education. As I said, he has no prior felony convictions. He has no recommendations for any sort of psychiatric evaluations or treatment. He has no substance abuse history. He has no failures to appear for the few misdemeanor and civil charges that he's had in the past. Your Honor, he isn't a flight risk. He immediately retained counsel for those reasons, Your Honor. And additionally, the release questionnaire states that he is homeless. That is just simply not true. He resides with his wife and his children in the city of Mesa. So we would ask for an OR release, Your Honor.
All right, does the county attorney's office want to respond?
Yes, Your Honor. The brandishing means that you're using the gun to intimidate, and the facts in the Form 4 lay out how he did show it and how he moved his body slightly in the altercation. It was during the altercation when the other things were being said, so he participated in showing that handgun in order to be a disorderly conduct weapon, and those facts support of finding a probable cause at this stage.
Your Honor, if I may respond to that in referencing the Form 4 itself, the allegation that Mr. Quillen turned his body and raised his shirt simply to show the grip of the handgun only occurred after one of the alleged victims took a fighting stance toward him. He was acting in the potential for self-defense, which is a constitutional right, and it is a right here in Arizona.
All right. By the way, if you would please finish filling out and filing the notice of appearance.
Yes, sir.
Before you leave the building. And I am going to set a secured appearance bond in the amount of $1,500. Conditions of his release include not returning to the scene of the alleged crime or having contact with victims or witnesses who were present. And his next court date will be, let me get up here, July 11th at 8:30 in Superior Court in downtown Phoenix.
Thank you, Your Honor.
All right.
Thank you.